Hi, this is CPA and Certified Financial Planner Rick Puntoro. For over 20 years, I've guided and built a roadway for my clients to reach their financial goals. I am your host of the Puntoro Financial Fitness Show. Now, today's show, we'll speak about the best practices to follow for businesses and individual employees as it relates to employment law. Now, my esteemed guest today is Jeff Ettenger, an employment attorney, commercial litigator with the law firm of Schwartz Ettenger, located in Melville, New York. Jeff can be reached by telephone at 631-777-2401 or visit his website at schwartzettinger.com. So thank you, Jeff Ettenger, for taking the time of your busy schedule to discuss a very important topic, employment law. Now, you can't be financially fit if your business is not in good order when it claims as it relates to employees and making sure you're running a tight ship, right?
First of all, thank you for having me today. I really appreciate it. You are 100% right, Rick. The reality is if you're a business owner in today's market, you really need to protect yourself. There are so many different ways either your employees or the government can create issues for you which will negatively affect your financial future.
Great. And so walk us through the services the firm Schwartz Ettenger PLLC. For our listeners, obviously we work together, so I know in detail what your fine firm does. But maybe you can help our listeners and articulate specifically what you're, as a partner of this fine firm, what your expertise is. Absolutely.
Our firm's goal is to generally service employers in all of their needs. So as you indicated, I am an employment lawyer specializing in day-to-day employment assistance, discrimination, sexual harassment, wage and hour. We also assist employers with corporate documents, with operating agreements, with commercial leases. We can also help their clients with planning their wills and their financial future, as well as a wide variety of different commercial litigation if you're having disputes with vendors, shareholder issues. So we try and help an employer in every phase of their business and personal life.
So what does your day look like? What does your working day look like?
Well, the interesting part about that is for me, being an employment lawyer and a commercial litigator, it's kind of split in two different ways. So I spend a good portion of my day helping clients with their day-to-day employment needs. If they have an employee issue, an issue with attendance, an issue with disability, an issue with COVID, drugs and alcohol, bullying, things of that nature, I walk them through the best practices on how to get through that situation to avoid liability and obviously to keep your business operating so that you can make money. And then I spend another portion of my day actually litigating cases where an employer either brings a lawsuit or gets sued. It could be for discrimination. It could be for sexual harassment. It could be a wage claim. It could be a commercial dispute with another company. It could be an internal dispute with other shareholders. So it's kind of a balancing act between helping clients with their day-to-day needs and litigation when unfortunately things go in that direction and it's unavoidable.
So perfect. So you work, you can help an employee, you can help a business and employer. So, specifically talking about an employer and executive, tell me, walk us through the listeners and such, what you need to do when you're in the process as an employee with regards to employment agreements, having your best interest in mind as an employee executive of a company. Let's walk us through what you can do to help a client and what our listeners that are executives and employees of these companies that can listen to your story.
Sure. So one of the things I obviously do is help employers, but I also do help employees because I do have high-level employees who will contact me and say, I'm starting with a new company. They've asked me for an employment agreement, and I need to know how to properly negotiate that agreement, and more importantly, what is and is not in the agreement that I need to protect myself in the future. And a lot of times, employers will put in cumbersome clauses with non-competes or non-solicits that really could impact you in the future. And the reality is, when you start with a new employer, there's a lot of optimism and everybody's excited and happy. But when things go awry, either you want to leave or they want to terminate you, you need to know what your potential exposures are, your rights and your liabilities, and most importantly, your restrictions. So when you sign an agreement of that nature, you really need to understand what you are and are not getting. And in a lot of cases, the employer is so excited about the monetary terms they're receiving, they ignore the non-monetary terms. So if they come to me for a fairly low cost, we can assist them in negotiating those non-monetary terms so their future is protected.
Sure. And then even on the monetary, they look at the salary only, and we've got to look at the 401k, the pension, maybe there's some stock options available. So you have to look at the whole package. We can help folks in conjunction with the legal elements that an astute attorney like yourself can help them with. An interesting thing, and there's a parallel with, financial planning, wealth management and such when it relates to employment law, right?
100%.
There's a tremendous parallel. The interesting thing is you have to plan. And the last I checked, to plan is not, hey, by the way, a year into your employment, you have this employment agreement. Jeffrey, can you help me with, certainly you can be helped, but it's always better to plan up front, right? If you're doing financial planning, you don't want to do financial planning retiring at 65 and do it at 65. You want to start early, right?
Well, a couple of examples that you're 100% right. Once you sign it, you're bound to it. And a lot of times people have to make a decision, especially if they have multiple job offers or they're going to leave a secure job for another job. Is this agreement so cumbersome that I'm not going to sign with this company, or are these terms negotiable? A good example, like you said, is you want to have certainty. So if a company gives you a wage, and then they have a discretionary bonus. If that bonus is 100% discretionary, the company a year later can say you're not getting a bonus and you have no rights under your agreement. So you need to negotiate defined terms where if you establish certain criteria, you get that bonus. That's not something that somebody would normally think to negotiate when they start new employment, but it's so vital as they go through their employment. And on the same note, if they exit the company, a lot of companies are going to ask for a severance agreement or a separation agreement, which again would further restrict their rights to get new employment or otherwise. And they need to understand what they're signing and what it means. Yeah,
so it's an interesting thing when you sign off on a contract like that, a employment agreement, you're bound to it, and you have limited things that you can do.
100%. You really have to be cautious in negotiating the agreement, and then obviously if during employment the employer asks for a new agreement, you have to be really cautious as to determine why, what it means, and what you're going to do about it. And at that point, usually you have more leverage to negotiate a better agreement because you're already there.
Yes, and discretion is not, it's not your discretion, it's your employer discretion.
You want to be in a position where your rights and benefits are defined.
So we are going to take a short break for commercials. Be sure to stay with us. We are talking about employment law from an employer and an employee's perspective, and we have our guest, Jeffrey Ettenger, here today.
Thank you.
If you were listening to us before the commercial break or just joining us, welcome to the Puntoro Financial Fitness Show. Be sure to listen in every Thursday at 4:30 p.m. right here at 103.9 LI News Radio. This is CPA and Certified Financial Planner Rick Puntoro of Puntoro Financial Services, the comprehensive financial planning firm, and Bernstein & Puntoro, the tax accounting and business consulting company. I can be reached by telephone at 631-694-5645 or visit my website at puntorofinancial.com. I am joined today by my friend and esteemed guest, matrimonial attorney Jeff Ettenger, sorry, Jeff, an employment attorney and commercial litigator with the law firm of Schwartz Ettenger, located in Melville, New York. Jeff can be reached by telephone at 631-777-24001, or visit his website at schwartzettinger.com. Now, before the break, we were speaking about the best practices to follow for businesses and individual employees as it relates to employment law. Before the break, we left off with a discussion of best practices for employees, right? Executives or employees when they move over to a new company with regards to contracts, agreements, etc. And now as a perfect segue, let's talk about, because the scope of your practice obviously is very big with working with businesses. Let's talk about businesses as it relates to employment law, best practices and the like. And I want to start off with, so what type of action does an employer need to do when operating their business to ensure that they are legally compliant, right? You could have this great business. We want to make sure it's running sound. We want to take care of our employees. We want to make sure that our business is not at risk for any discrimination suits or anything of that nature. Walk us through best practices, handbooks, etc., things that we ought to.
Absolutely. So as most employers know, it's a minefield right now. Between New York City, New York State, local laws, and the federal government, there are a myriad of different laws and regulations that they have to follow, which could create significant exposure and liability to them. And unfortunately, a lot of employees, especially newer and younger employees, know these laws, and if you don't comply with them, they're going to either file a private claim or they're going to file a claim with a government entity, and you're going to have a world of problems. So most employers are very good at what they do. What they're not good at is being their own human resources coordinator and understanding all of these different things and how to handle it. So you really need a lot of help. And it does start generally with an employee manual, which is not mandatory under the law, but these manuals set forth many of the rules and regulations of your company and the laws that you have to follow. So it's a great tool for you and your employees. Employers are required to give their employees sexual harassment training on a yearly basis, which could lead to massive penalties and fines if you do not follow that, especially in the world we live in today. And again, an employer really needs to either have a human resources consultant on staff or somebody that they can contact, or obviously an employment lawyer like myself that can guide them through all of these different pitfalls.
Yeah, in a sense, right, if you don't have that handbook, it could put the employer more at risk if there's any kind of case out there. You didn't show guidelines in terms of how to conduct yourself. You could be more liable in a certain case, discrimination or otherwise, right?
Well, you need a written discrimination sexual harassment policy already. That's mandatory under the law, as well as the sexual harassment training. But yes, within the handbook, a lot of these rules and regulations are going to be set forth. And if you don't have them, you're kind of swimming in an unknown pool when things come up. If you have it, it is kind of your constitution on how to treat your employees and on how to handle difficult situations.
So it's your handbook for guidance, both from an employer and employee perspective. It gives.
Yeah, I think it helps both parties. It lets people know what your policies are and the rules they have to follow as an employee of your company. And it also allows them to understand what their rights are, and for you as an employer to understand those rights as well and ensure that you follow them.
So what do employers need assistance with on a day-to-day basis? What are you finding what you do to help folks as it relates to, there's always things that pop up, wage and attendance issues, overtime, right, for, some of the rank and file opportunities,
100%.
Bullying, sexual harassment, discrimination, and the like.
If anybody who has an employer will tell you, if I have employees, I have problems, because you can't just run your business and everybody's happy and everybody gets paid and everybody goes home on Friday afternoon and there's no issues. There's always issues that come up with employees. And the reality is, as I said, the employer is not trained on how to handle those issues. They want to run their business. They want to make money. These are distractions. They take away from their ability to run the company and obviously to make money. And in some cases can cause a lot of personal aggravation when these issues become larger. So yes, it could be an attendance issue. It could be somebody claiming that they have a disability. It could be two employees getting into an argument or a fight. It could be somebody making a claim of discrimination or sexual harassment. It could be a wage issue, overtime issue, minimum wage, tip credit. There are literally a million things. And with COVID in the last 2 years, it's grown proportionately because there are so many COVID-related issues alone.
So you got to follow all these different rules. COVID has brought another new opportunity for compliance.
Yes,
and so many different, and it's difficult. It's a moving target sometimes.
It's a moving target. The laws have changed so many times in the last 2 years, I can't even keep up with them. So it helps to contact somebody and say, what do I do? Because I've been doing this for 25 years. I've seen every different kind of situation. I understand what they're going through, and I'm trying to give them pragmatic advice so that they can avoid liability and allow them to go back to running their business. So whether it be crafting a letter or an email, or just guiding them through how to deal with a difficult employee to get to a point where you get to either them working as they should or terminating them in the best possible way to avoid issues and litigation that arise. And that's the great thing about being a litigator. I see the other side when these issues are not resolved correctly and the exposure the employer faces when they have to deal with those litigations.